Hello, and thank you for joining us for today's American Tinnitus Association harassment training. My name is Jennifer Jackman, and I'm an attorney at Whiteford, Taylor & Preston and counsel for the ATA, and I'm happy to be providing this training for you today. So what's our agenda today? We're going to cover an overview of discrimination laws, what constitutes the workplace, because the workplace is actually a lot broader than you may think. Liability for board of directors conduct. Yes, you can create liability. The duty of the board of directors. We're going to have some hypotheticals and then go over some best practices for how to avoid harassment claims. So let's talk first about what factors are protected. So as I'm sure you know, there are a lot of protected factors under federal law, which include color, national origin, race, religion, sex, age 40 and over, pregnancy, disability, and genetic information. But there are also factors that are protected by local law or state law. Just to go into some of the DC protected factors, it includes all of the ones we just discussed for federal law, as well as childbirth or related medical conditions, marital status, age, and instead of age being 40 and over, in the District of Columbia, it's actually 18 and over, personal appearance, so hairstyles, things like that, sexual orientation, gender identity, family responsibilities. One that's kind of a doozy these days is political affiliation, matriculation as to whether or not you've gone to college, and credit information. So there's a whole legal definition for what constitutes workplace harassment. And the key to that is that the conduct has to be unwelcome. So the first component is unwelcome conduct. And that unwelcome conduct has to be made a condition of employment, or to be such an extreme example of it that it creates a hostile environment. And that hostile environment is a legal term of art, and that means it has to be severe enough to be offensive to a reasonable person, such that it really makes it the person not want to go to work, or it really affects the terms and conditions of their employment. So what kinds of conduct can be considered harassment? It can be jokes, comments, even emails, anything that unreasonably interferes with an individual's work performance. To be a harasser, you can be a supervisor, it can be harassment by a coworker, it can even be a third party or a vendor like the FedEx delivery person, or even a board member. And to be harassment, it does not have to result in a tangible employment action. And a tangible employment action is termination or demotion, a change in the benefits that the person receives. And to be unlawful harassment, it doesn't need to do that if it's hostile enough to become that hostile work environment. So generally, what does not constitute harassment? And that's important. So petty slights, annoyances, and just isolated incidents, unless they're extremely egregious, will not rise to the level of illegality. Doesn't mean you should do it, it just means it wouldn't create a claim. To be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to that reasonable person. It doesn't include just having an annoying coworker or a demanding supervisor. It also doesn't mean someone who's a bully. Again, that might not be consistent with your actual beliefs and what you're going to allow in policies. But if the bullying is done on an equal opportunity basis, then it's not illegal. So let's talk a bit about sexual harassment. This is a really hot topic these days. After the Me Too movement several years ago, it's really changed what the norms are and what's allowed. It affects all industries, both in private and the public sector. And it's important to know that sexual harassment can occur without an employment relationship. So as a board member, even though you're not technically the employer, you do represent the employer, and that could still be sexual harassment. It could happen with the vendor, as we discussed before. Harassment can arise to criminal behavior. When that happens, you want to get the police involved. Power imbalances can prevent reporting. So someone may be getting harassed, but you may not know about it because the person's afraid to come forward. And when there is a power imbalance, consent is questioned. So oftentimes you'll hear examples of, well, it was a consensual relationship between the supervisor and their employee. But the problem is when the supervisor has the ability to affect the terms and conditions of employment, it then kind of questions whether it really truly was consensual. Failure to respond appropriately by an employer can be costly. It can result in claims that could be very expensive and could have been avoided if action had been taken. And as we'll talk a little bit later, alcohol is no excuse. So what exactly is sexual harassment? It's a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964. And it's defined again as that unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct that's of a sexual nature will constitute sexual harassment when this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. So just like the other kind of harassment, any kind of harassment based on a protected factor, the key component is that it's unwelcome. And if it's going to become that hostile environment, it has to be very pervasive. So let's talk about what is considered unwelcome conduct. Well, it has to be conduct that the person did not solicit or invite. For example, if someone's telling dirty jokes, that may be, and then you respond in turn, my recommendation would be that you don't respond in turn, but someone might argue that by starting those jokes, they invited the conduct, and thus it was not unwelcome. The conduct was undesirable. And it's important to know that just because someone is silent does not mean that they are consenting or that they think it's okay. Oftentimes people are surprised when something happens and don't know how to respond. So silence can be their first method to respond or not respond. The recipient who remains silent, though, might be sending mixed signals because someone might assume that that conduct is okay if they're not objecting to it. How can sexual harassment occur? It can occur in a variety of circumstances, and that includes but is not limited to when the victim, as well as the harasser, can be a woman or a man. The victim does not have to be of the opposite sex. There is same-sex harassment. The harasser can be the victim's supervisor, but they can also be an agent of the employer, a supervisor in a totally different area of the employment, a coworker who's at the same level, or even a non-employee with whom the person interacts at the workplace. The victim does not have to be the person harassed, but could actually be anyone who witnesses it and is offended by the conduct. Unlawful sexual harassment may occur without economic injury or discharge of the victim. So that was that tangible employment action we discussed before. It doesn't have to result in a tangible employment action to constitute unlawful sexual harassment. But the key, again, it has to be unwelcome behavior. So let's talk a little bit about a hostile work environment. The offensiveness and severity is measured from a perspective of a reasonable person. And who the reasonable person is your best guess, is my best guess. But it's typically, when you're looking at that, like from a juror's standpoint, would a reasonable person be offended by that behavior? And it's typically pretty easy to make that determination. But it is viewed from the perspective of the recipient. Would someone in their shoes be offended? Intention really doesn't matter when you're looking at this analysis. I will talk to you later about when intention may matter, but for purposes of establishing whether a hostile work environment exists, intent does not matter. It could arise from cultural differences. So an employee might be offended by a religious joke, another employee or coworkers may not be. But it's really the perception of the person who's affected by it. So what conduct could create a hostile work environment? Certainly sexual advances, especially when they're unwelcome. Grabbing and touching. You really should not be touching employees. Offensive jokes, offensive emails or text messages, repeated calls, emails, pages, and text messages. And that doesn't mean a supervisor that's demanding, but where you might see that is if they start happening in the evening after alcohol, after they've been drinking, they're sending text or emails that are kind of testing the waters or a bit inappropriate, or just keep going, especially if they're late at night. Offensive social networking posts. People can and have been getting in trouble just from what they're posting on social media. And there's a whole idea about free speech, but at the same time, if that free speech is now impacting a person's ability to come to work, the employees, protecting the employee will outweigh the free speech. Flirting, just flirting alone can create a hostile work environment if it's unwelcome. So what is covered? Supervisor harassment of a subordinate, that can be the quid pro quo you're probably familiar with. Coworker harassment, even if they are at the same level. Harassment by directors, same-sex harassment. So we talked briefly about those. So importantly, the harassing conduct can occur on or off the job, in or out of the office. And what is considered the office? We used to think that it might just be the four corners, that brick and mortar office where people work, but that's not the case. The office actually can include anywhere where the business is being conducted. For purposes of associations, and we'll get into more detail, that can be conferences, that can be happy hours, board meetings, lunches, anywhere where they're doing their job, or socializing or interacting with people for their work. That's considered the office. So the workplace is no longer just the office. It includes bars, cocktail hours, directors' meetings, work meetings that are off-site, even text messages and emails after hours, because it can permeate the working conditions once they're back at work. Annual conferences certainly can be considered the workplace. And for nonprofits, it's a unique hybrid because you've got both paid employees and directors who are involved in the governance. So oftentimes you don't have volunteers involved, but here you do. And so directors may actually have perceived authority, and with that perceived authority, they can create liability to the organization. So employees may actually think that the directors have the ability to affect their terms and benefits of their position. And so that perceived authority can be what creates the liability. And in that same vein, the directors and staff have frequent interactions, and the directors may incorrectly assume that the laws don't apply to them when in fact they do. And a lot of times events can occur when you're not in the middle of a pandemic anyway. They involve alcohol and travel. And for whatever reason, when you mix those two and people get away from home, it sometimes leads to what would be unwelcome or inappropriate conduct. So can directors create liability for harassment and discrimination? Absolutely, yes. Sexual harassment and other harassment can certainly create a hostile environment for employees, even if the directors don't directly supervise them. And the ATA can be liable for harassment of employees by third parties. So the employee may be, let's give an example, may be required to attend meetings and conferences. That employee must be able to attend those meetings and events without being exposed to harassment, because this is a condition of their employment. So if you have an employee who's working with a publications committee or a governance committee, and they have to attend those events and be around those board members, if there is a board member who is who is behaving in an inappropriate way, that affects their terms and conditions of employment. In what settings could a director be at risk for harassing an employee? Well, like I said, directors' meetings, committee meetings, conferences, parties and receptions, and happy hours for sure, conventions and annual meetings. All of these areas can be a setting for harassment. Pretty much anytime alcohol is served at an event, inhibitions can be lowered and cues are missed. People become more touchy-feely, become more open to saying things that they may not say if they were in the middle of a board meeting. So some examples of potentially harassing conduct by directors could be dirty or off-color jokes at ATA meetings or events, unwanted touching, invitation to hotel room or home, invitation to a restaurant where suggestions of dating and sexual conduct can occur, comments at meetings and events that are dismissive, favoritism that the employee perceived as based on a protected factor, and becoming more touchy-feely at happy hour. Any of these are potential examples of conduct that could be harassing. Any comments based on a protected factor. So that's when we talk about dirty jokes. It could be racially or religious-based jokes. Anything that's based on protected factor that is unwelcome could be considered harassment. So how can you avoid harassment? Well, one thing you want to do is create an atmosphere that's free of harassment. Leadership needs to model that appropriate behavior. You're leading by example. You also want to know the ATA's policies and complaint process and ensure that they are followed. And we're going to go into that in detail today. You want to give people space. That's the no touchy rule. There's no need to touch people and hug. Avoid interoffice relationships. And from a board of directors standpoint, that means avoiding relationships with employees. Do not fuel gossip and rumors. And don't stereotype. You want to be accepting of differences. Treat each person with dignity and respect, and don't treat them differently because of a stereotype that you might have. Do not make comments about someone's body, their race, their ethnicity, or religion. And think before you speak. Sometimes things come out when you're on a roll, but you just want to make sure before you say anything about that could even remotely touch on a protected factor, think about it and whether it is appropriate. Watch what you drink, as we've talked about. So what is ATA's duty to prevent harassment? Well, the duty of the board of directors, you want to create that atmosphere that's free of harassment, modeling the appropriate behavior. And you want to monitor conduct of others and report and address conduct that is unlawful or violates policies. That doesn't mean you're the police. That doesn't mean you have to go to events and make sure that you're listening to what everybody's saying. But if you are at an event and you see something that is concerning, don't ignore it. You need to step in. It's that whole montage. If you see something, say something. Know ATA's policy in the complaint process and ensure that the policies are followed, and respond appropriately to complaints. You just want to make sure that you don't ignore them. The only thing worse than not having a good policy is having a good policy and not following it. So what about harassment against directors? I would expect that there's going to be changes in the laws to protect volunteers. The theory behind that is that directors should be able to attend events without harassment, especially when those are organizations that are related to what their career is. Some jurisdictions already have anti-harassment laws that protect volunteers. Typically that is with unpaid interns, and that includes California, Illinois, New York, and DC. Montgomery County, Maryland has a law that applies to harassment and includes volunteers. So it's employees including volunteers. So I would expect to see more of that. And while there may not be a legal cause of action, publicity concerns and morale issues could dictate. And so you don't want all of a sudden ATA's reputation to plummet because of some conduct that is being conducted towards a certain group of people or members or directors. ATA must maintain an environment that's free of harassment. So you want to respond to concerns. Ignorance is not a defense. Now, if you don't know of the concern, that's one thing. But if you know of it and decide not to investigate when you should, that's not a good thing. You want to be proactive and monitor behaviors, take complaints seriously and keep them as confidential as possible, taking appropriate action, corrective action against directors or employees who violate the policy. And not every incident will require discipline, and we'll talk briefly about how you kind of figure that out. But when it's appropriate to take action, you need to do so. Communicate your harassment and discrimination policies to all members of the board of directors, and understand and be respectful of cultural differences. Again, avoiding stereotypes is really critical. So what is ATA's harassment policy? Well, the ATA does not tolerate harassment toward any employee, director, officer, volunteer, donor, member, or vendor of the association. How you report is, if any employee, director, officer, volunteer, donor, member, or vendor believes they have been harassed, then they are encouraged to report their harassment as soon as possible in writing as follows. And that whole group of employees, volunteers, donors, members, and vendors are to report it to the CEO. If the CEO is involved in the alleged harassment or is alleged to be the harasser, you need to report it directly to the chair. Directors and officers report it directly to the chair. But if the chair is involved in the alleged harassment, you want to report it to the vice chair. One thing that we're going to talk about is the report, and what the policy requires is it to be in writing, but you can't require it to be in writing. If someone verbally tells you that reports a complaint to you and they're uncomfortable putting it in writing, that doesn't mean you can't take action or that you shouldn't take action. We'll talk about that later. So reporting harassment, and here's just a chart that goes through what we just talked about. So if it's the CEO, chair, or vice chair, do not respond to a report. Then you want to submit a copy of the original report in writing if it exists to the following. And so if you're the CEO, you go to the chair. If it was supposed to go to the chair, it goes to the vice chair. If it was supposed to go to the vice chair, it goes to the secretary. And if it goes to it's supposed to go to the secretary, it should go to the treasurer. And that is set forth in your written policies. So what constitutes a complaint? The ATA's policy, like I said, provides for submission of a written complaint. But if a complainant comes forward with a concern but does not put it in writing, what do you do next? So what you need to understand is that a complaint does not have to be in writing to require investigation. If you're put on notice of an issue that involves some sort of unlawful harassment or discrimination, you can't not investigate simply because they're not putting in writing. There can still be liability for failing to investigate a verbal complaint. And keeping in mind that the complainant does not need to use any kind of magic words. They don't have to say, I'm coming forward to make a harassment complaint. If they come forward and tell you some conduct that you identify as being potentially harassing, you need to do something. And if they don't want to put it in writing, you can always follow up with an email to them summarizing the conversation and asking them to correct anything that you got wrong. So what constitutes the complaint? It's really any notification by the victim or a witness of improper conduct. And what if they tell you that they're coming to you as a friend and not as an employee talking to a board member? Well, you have to remember you can't wear two hats. You have duties as a board member that you can't dismiss. What if they tell you that they're just venting or that they don't want you to do anything? Or what if it's another board member who is who's not complaining but is just relaying a story? These all constitute complaints, and you can't take that board of director hat off when it's convenient. You have to go ahead and do the hard thing, which is require the investigation. If the conduct sounds like it relates to any protected factor, regardless of intention, you should report it and take action. So how does the investigation process work? Well, the ATA will attempt to maintain confidentiality consistent with its need to conduct an adequate or appropriate investigation, and they will then take prompt corrective action in response to any harassment or retaliation. So who should do that investigation? And it really depends. And when you go back to that earlier chart as to who you report it to, it really determines where in the line of hierarchy the alleged harasser is. So if someone is complaining about a coworker, and if you have HR or someone that's trained at ATA that can conduct an appropriate investigation, as long as that person does not report to the person who's allegedly engaging in harassing conduct, then that trained investigator can do the investigation. But if that harasser or alleged harasser is within that chain of command and can control the working conditions of that person who would otherwise investigate, you really don't want that person to investigate. So if they report to the person, you wouldn't want that. Oftentimes it's best to have someone outside, even counsel, do the investigation, because that protects you from any appearance of impropriety. It helps protect the integrity of the process, and it allows people to come forward and share concerns that might not otherwise do so. So talking a little bit about corrective action. Under the policy, anyone who is found to be in violation of the ATA's policy against harassment will be subject to discipline up to and including discharge, cancellation of the contract, or expulsion from the board. So what does zero tolerance mean? Does zero tolerance mean that anytime anyone violates it, they have to be terminated, or if they're on the board, kicked off? And the answer is no. That's where it really gets into intent. If you recall earlier, I said we'd talk about intent. Intent doesn't have anything to do with the investigation in terms of whether inappropriate conduct occurred. But when you're talking about what corrective action to take, you do want to look at intent. Did this person know that what they were doing was inappropriate? Or were they using language that they didn't realize had a negative connotation anymore, or does now? Were they stereotyping inappropriately, and does education just need to be done? Do they need some training? Is a written reprimand enough, or was it so egregious and obviously intentional that you do need to take more serious action? One of the things you always need to be mindful of is the potential for retaliation. And retaliation is an adverse action taken against someone who has complained of harassment or discrimination, has participated in an investigation, or is taken because of that protected activity. So if someone comes forward with a complaint, suffers an adverse action in their employment, and that adverse action is taken because of that complaint, that's a protected activity, and that could be illegal retaliation. And at the ATA, retaliation is, of course, strictly prohibited. Board members have a duty to protect complainants from retaliation. So if you are investigating a complaint, you need to look at how do you protect the person who's come forward. Do you need to put anybody on paid leave? And if you were going to put someone on paid leave, it should really be the person who is alleged to have been the harasser, not the complainant. Do you need to shift who's reporting to who, and making sure that any actions you take, even though they might be for the protection of the complainant, couldn't be seen as retaliation as well. My best advice would be consult with counsel before you take any such actions. Retaliation can be more serious than the actual underlying complaint. Oftentimes, there might be a finding that there was no discrimination harassment, but the person took an action in response to that protected activity, which gets the association in more trouble. So what do? If you receive a complaint, follow up with an email documenting the complaint. If it's in writing, follow up saying that you've received it. If it's verbal, follow up with an email specifying what was told to you. Avoid discussing your own opinions in the email. You want to just report the facts, just as reported or observed by you. So going through what they told you. You don't need to put in this document whether they appeared credible or anything like that. And then who should investigate? That's, going through what we discussed, you need to make that determination. Again, it depends on who the alleged harasser is. And then you need to take action to protect the complainant. So let's go through a couple hypos. You're at an ATA event. The conference events for the day are over, but some directors and staff are hanging out in the hotel bar. You see one of your directors buying a round of shots. Any concerns? In this situation, I would say yes. So you really, when we talked about modeling good behavior, you do not want to be encouraging excessive drinking with staff because, again, that can lead to more issues. It can lead to bad behavior by the staff or by the others that are participating in shots. So I would go in and try to dissuade that director from buying more rounds of shots. You also notice a member is very cozy with a staff member. Frequent touching, flirting, and the staff member is not complaining. Do you have any concerns? And here I would say, yes, you should be concerned. Just because the staff member isn't complaining doesn't mean you shouldn't intervene. Again, there's that potential power imbalance, and the staff member might think that the member has the ability to affect the terms and conditions of their employment. So I would go over there and intervene. It doesn't mean you have to reprimand the member and say, stop flirting. But you might just go over there and see if that member needs you, the staff member needs you as a resource. Just kind of put another person in there, separate them a bit. Another hypo. After a director's meeting, you are cleaning up your items. Staff member Monica is in the room with you. You have known Monica for years. Monica tells you she needs to vent and is coming to you as a friend and not as an employee to a board member. Monica then tells you that Director Phoebe has been texting her at night asking her to go out drinking. Monica also tells you that the last happy hour, Phoebe had her arm around Monica and made her feel uncomfortable. What do? Again, this goes back to the fact that you don't wear two different hats. When you're a director at all times. And so even though Monica's coming to you and saying she just needs to vent, you need to have a serious conversation about Monica, about your duties as a board of director, and that you can't just ignore them. If she really is adamant that she does not want anything done, then at a very minimum, you need to email her afterwards, telling her this is what you understood, that this is what she reported to you that happened, that she has specifically told you not to do anything, and inviting her to bring back any additional concerns to you. I've had a case that I had to defend before where someone came to a supervisor, just was putting them on notice, but said they didn't want to do anything. Unfortunately, they did not follow up with an email, and that became a dispute of fact that kept them in the case for a long time because the person said that they did ask them to do something. And so you definitely want to document that. What if the conversation is about the executive director and Monica specifically asks you not to do anything? Again, you want to just document that she specifically told you not to do anything, what was reported to you, and then be mindful of any kinds of concerns that might be raised in the future. That's what you would do at a minimum. You may want to even consider doing an investigation, but if she's not going to cooperate in that, it could actually make the situation worse. What if you're attending an ATA board meeting and some staff members are there? One of the directors who likes to tell jokes tells a joke that begins with, so a priest, a minister, and a rabbi walk into a bar. At the end of the joke, most people laugh. You do not know the religions of some of the people in the room. Any issues? Well, of course there's issues here. That's a religious-based joke. We know religion is a protected factor. What do you do in that situation? There are a few things you can do. You can jokingly say to the person, okay, you don't want to do that. That's inappropriate. Or you can take the person aside afterwards and tell them that they can't do that and why that's inappropriate. But if you do that, I would then also talk to any staff that was in the room and let them know that you've taken action and that that was not appropriate and you're sorry that they're privy to that. That's one thing you can do. Other things that people do are, you could say it's a red card, right? If you have like safe language in your group where if someone's going overboard, you could say, okay, that's a red card. It kind of brings a little levity to the situation, but it also puts the person on notice that they've engaged in inappropriate conduct. What if the joke was about race? Of course, you'd have the same issues. It's a protected factor. But what if the joke was about blondes? What if it was a blonde joke? Well, it really depends on where you are. I would avoid those as well, because in DC, we now know that personal appearance is a protected factor. Here's another hypo. So Monica is a staff member who works with the publications committee. Chandler is the committee chair. When Monica is asked to report at the meetings, Chandler is very dismissive of her and comes across as a bully. Ross is another staff member who works with the committee. Chandler treats Ross more favorably and praises his work. Any issues here? Yes, there's issues. This could be perceived as potentially a gender difference, right? Why is Monica being dismissed while Chandler treats Ross more favorably? So you need to make sure that you're not playing favorites or treating people different, because Monica might assume it's because of her gender. It may just be that Monica does not have any good ideas, but even if she doesn't, you want to treat her with respect. So let's talk about best practices. One of the things you want to do is make sure that as a director, there is a code of conduct for all the board of directors. You want to adopt that code of conduct, and that covers conduct towards employees and directors. It just basically sets forth the minimum standards. That's different than your code of ethics. It notifies directors of consequences if they engage in offensive conduct. And those consequences might include removal, but you want to put forth what the expectations are and what the consequences are. It should also outline the complaint process. Again, this is different from any ethical codes as well as the conflict of interest policy. You should also be proactive and conduct training, just like you are today. Annual training is really important for everyone. This includes staff, managers, and directors. So you want to make sure that you're constantly conducting training. Understanding power differences. So as we talked about the power imbalances, staff may perceive directors as having power to affect employment decisions. They may view directors as their boss. So you want to make sure you're avoiding abusive power situations, because employees might say yes to unfair requests due to fear of employment action and may remain silent or not speak up because they're afraid of retaliation. You want to model and monitor appropriate conduct, setting the tone, leading by example, making sure you don't tolerate those off-color jokes. If you see something inappropriate, don't ignore it, but address it. Do not ignore complaints. Make sure you act upon them and be really vigilant at those events with alcohol. Like we said before, making sure you're not encouraging staff to drink to excess. Avoiding retaliation is critical, and that's what we talked about, that adverse action taken against someone who has complained of harassment or discrimination or has participated in a protected activity. Ensure that the ATA takes steps to protect the complainant from retaliation. And when you're doing that, making sure to warn the accused about retaliation and promptly investigate any complaints or concerns of retaliation that are raised. And that covers everything we have. If you have questions, please let the board chair know, and they can get back to me if they don't have the answer for you. And I wish you luck.